Welcome to the Half Empty, Half Full Consumer Advocacy Radio Show. Listen in nationwide on the Tan Talk and Starcom radio networks with your host, Lori Zook, the consumer champion. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to learn something new. Get smarter faster and avoid scams and fraud. All opinions are that of the host and guests, and all shows are for educational purposes only and not to be construed as legal advice. Here's your host, Lori Zook.
And welcome to the show. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to get smarter faster. My guest today is Eric Seidel.
Hey, Lori.
He's famous. We're going to be talking about what you as a consumer need to know about class action lawsuits. Welcome to the show, and share with our listeners a bit about yourself and your background.
Well, Laura, here in the Tampa Bay area, a lot of folks probably know me. I was the consumer lawyer on Fox 13 for about 20 years, from the early 90s, 91 through about 2010. And my basic function was as a troubleshooter for the consumer. People would write to me if they had a problem where they couldn't afford an attorney, or maybe it was something that wasn't worth filing a lawsuit over, and we would go to work for them. Everything from car repairs to rental disputes and ordering things that you didn't receive and things like that. It was a very interesting gig.
Sounds like a lot of fun, I would think, from your end, right?
Yeah. Oh, it was terrific. It was a great, nearly 20 years. But, TV, as a lot of people are noticing, is being superseded by the Internet. And that's why so many of your shows, obviously, are online. The Internet is taking over. Advertising is going down. So a lot of cutbacks. And I sort of saw the writing on the wall, and I decided to branch out. And I'm doing a lot online and a lot with my own law firm. So just an interesting move, and certainly helping a lot more folks here in the Bay Area still.
Great. I'm glad to hear that. We're going to jump right in because we're going to be talking about mass torts, also called class action lawsuits, correct?
Exactly.
Okay. Now, first explain to me, how does a class action lawsuit get started?
Sure. Well, it's usually something that affects a lot of people or a certain group of people, but they all have similar damages or damages that were caused by the same thing, so that we can then break it down and say, okay, well, we were all hurt by this, but you were hurt this much, you were hurt that much. So it's still very similar in the actual what we call a tort. So they were hurt by the same thing. The damages don't necessarily need to be equal. In many cases, though, they are.
Okay. Now, when something happens, somebody goes to an attorney and says, something's terribly wrong. Let's say I go to an attorney and I say, hey,
sure,
Eric, something's wrong. How do the other people all get notified? I know sometimes I see commercials on TV and they say, hey, if you've been injured by this or that, to call. But how does the attorney determine that this could be a class action before they go to advertise it?
Exactly. Well, certain attorneys specialize in mass torts and class actions, and that's one of the things that we do at my firm, which is McIntyre Thanacetus. We have more than 30 attorneys all working on various functions of the law, everything from personal injury to mass torts. And one of the things that we do is we look at the type and the amount of the damages. If somebody is tremendously hurt, let's say they've lost a leg or someone has died, or you have one of these terrible, terrible situations of damages, you don't want to think about a class action. You're thinking about the cost to this person's relatives, maybe children, that sort of thing. So that's something where you would consider a private lawsuit. If it is something that is a smaller damages, but you know that a lot of people are being affected, like let's say a certain deceptive advertising being done by a company knowingly, and this person's only been out maybe $20, well, certainly you don't want to go through the entire legal system to get their $20 back. The filing fees alone would be 20 times that. So what you want to do at that point is think about, are other people affected, and maybe this might be a possible class action lawsuit.
Okay, well, that leads me to the next question. Is it better to join a class action or to keep your own lawsuit separate? How does a consumer determine that?
Very good question, and I get that a lot because we're handling both the BP oil spill class action settlement. We're handling the NFL class action settlement. I have a lot of NFL players come up to me and they say, how do I know whether I should be going for this concussion settlement or whether I should file on my own? Well, the answer is the amount of damages. If someone has been affected so much so that they feel that if they were to hire an attorney, which is expensive, go to court, which is expensive, litigate in front of the judge, which is very expensive, the jury, take a chance on the legal system and all that, and then figure that you will still benefit by getting damages for what you deserve, then you'd want to go privately and hire your own attorney. If you feel that you don't want to go through all that and other people are similarly affected and there is a class action settlement in the NFL case, for instance, yes, that's something you'd want to consider joining, and we would make that on a case-by-case determination.
All right, well, let me ask you another question then. If you have a group of people and it's a class action lawsuit, maybe that settles out first. What if somebody that wasn't part of that has a private attorney afterwards is filing a lawsuit also? Does that first class action take precedent as far as the awards, or is it, even if, you know what I'm saying, even
Sure.
if the other one is after?
And that's a danger. Very often somebody could go right ahead and pursue their own private lawsuit with all the expenses that we talked about, only to have the judge say, well, you should have done this under the class action, and now it's too late, dismissed, and now they're out both.
Wow. Okay. Well, let's talk a bit about the BP oil, the oil spill. How
Sure.
did it affect Florida businesses, and is it still affecting Florida businesses?
Yes. Well, actually, you can still join the class action lawsuit. Believe it or not, BP has, if you will, been, I guess the expression might be hoist by their own petard. They continued to appeal this settlement, so much so that it extended the application deadline for the settlement. So you can still run the numbers, and in fact, I can run the numbers for any company or any business that's interested. And we have at least 5 or 6 months till about early June at this point, to file under the settlement, which has already been, you will have a certain amount of damages already chosen for you if you meet this formula.
Okay, so they have exhausted all of their appeals at this point. They have to pay out, correct?
They up to the Supreme Court, correct. Now, they can still appeal on different matters to lower courts, but they can no longer go for the Supreme Court appeal. So they're not going to say this has to be dismissed at this point. Anybody that is filing and deserves the money, chances are they're going to get their money. And we have been getting checks every month. We were talking about this, Lori. It's very interesting.
Right.
For the past 5 or 6 months, our law firm has been getting 3 or 4 checks a month for our thousands of clients. Now, it's a trickle, but now that the Supreme Court has turned down BP's last appeal, that was their last gasp. So we're going to start seeing that explode.
Now, do you find it frustrating when a company like BP does that? Obviously, they knew they did wrong. Is it the lawyers that are holding it up because they want their monthly, their hourly billing, or what holds it up when you know you've done wrong?
Sure.
There's black and white.
It was very, very frustrating, Lori, not only for us, but mostly for our clients, because when BP agreed to the settlement, they made it sound like this is exactly what they wanted to do. They signed off on it. And then, just like certain insurance companies, after you're in good hands, they then decide, well, you know what, let's look at every little possible way to get out of paying this person. And that's what they were doing, including using the legal system.
A little bit frustrating.
Yeah.
So it's not too late to file a claim. Have you seen a lot of claims, and are you still seeing claims, people coming in now?
Fewer folks are coming in. In the beginning, when it first started, we were hearing from people, I would say maybe a dozen or more a week that wanted to sign up. Now I would say it's down to maybe 1 or 2, maybe possibly at the most 3 a week. But people still have the ability to join this class action. Now, many folks were thinking, this doesn't affect me because I don't live on the water, or my business is not on the water, or my customers are not on the water. And this had very little to do with that. It starts at the water, and then it continues to proceed all the way here in the Bay Area from the coastline all the way through Hillsborough County out to Plant City. So that's just using one company as an example. So that is miles and miles inland, including many cities and many counties. So anybody should look at their numbers and see if they should.
Okay, now, do businesses file, or can it be individuals?
At this point, the first settlement was very, very favorable for individuals. It was replaced by this second settlement, which we're operating under right now, which is actually much more favorable for businesses. However, if a business qualifies under this settlement and does receive a recovery, then they are saying that the individuals that work for that business have a right to apply. So we are looking at, once the company is getting paid, then applying for various individuals in their organization.
Okay, and how much money are people getting and businesses getting?
It can be a tremendous amount. It really depends on the damages. And what we look at, just to give a quick little example, would be like, let's say one of the causality formulas to look at is the V-test. You look at how much monthly the business was bringing in revenue from 2007 through 2009. Then you look to see whether there was a dip in any 3 months after the oil spill in 2010, and then a recovery. A certain amount doesn't have to come back up to the baseline, but it has to be a recovery of some sort in 2011, showing that this was a specific effect from the oil spill. Well, then you look at that and you can extrapolate using mathematics and the finances just how much of that went to the oil spill. We have we have filed claims as high as $12 million for local companies. We have several local companies that are in the $10 million range. And then we have some that are as small as $5,000 and $10,000. We're talking about individual mechanics, a few, a repair operation, that sort of thing. And then we have a sort of a mid-range, the air conditioning companies, the electrical repair companies, any ones where you see the vans out on the street like roofers and electricians and air conditioning. If you have a moderate-sized company like that, I would say we're seeing about in the six figures, $100,000, maybe $200,000 and up for those if they do have a claim. And again, they do have to meet the mathematical formula.
All right, now to find out if somebody has a claim. Now, this show airs nationwide, but obviously This is the west coast of Florida.
Exactly.
So if you're on the west coast of Florida, how do you find out if you have a claim?
And this applies not only for the west coast of Florida, but all through the Gulf. We're talking Alabama, Louisiana, parts of Texas. If you have, what you would do is we just look at the numbers and see if there is that dip in 2010. There's the V test, which I just described. There's also a decline only. In other words, you don't have that recovery in 2011. There are many different formulas. There's a modified V, and we use specialized software to analyze those numbers. So we just ask that they give us their monthly revenue, and we have a form, an Excel spreadsheet that we ask them to fill out. We have forensic accountants run that through the formula using a certain proprietary software. And once we look at that, we can tell within a matter of minutes, and we can get back to the clients usually within an hour or so, letting them know if they have a claim or not and approximately the value of that claim.
All right, great. We're going to take a quick break, and we come back, we're going to talk about the NFL settlement.
Terrific.
I've made a few. I've had my shells and kicked in my face, but I've come through. I need to go on. We are the champions.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health. Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
Hello, I'm Jim Velasquez. Does getting a lousy 1% on your CDs make you sick to your stomach? Inflation is hovering at 3%, so what's really happening? Allow me, Jim Velasquez, to send you my free report. If you haven't reviewed your CDs in a while, don't get this report. It will break your heart. If you want to fight back and beat the bank, text RETIRE to 72727 for this free report. Let's beat the bank. Text RETIRE to 72727 for your free report.
I've had my shells and kicked in my face, but I've come through.
Welcome back to the Half Empty, Half Full Talk radio show. My guest today is attorney Eric Seidel. By the way, he's not giving legal advice. We're giving educational advice to all of our listeners. So we've been talking about mass torts or class action lawsuits. And in this segment, let's talk about the NFL settlement.
Sure.
Okay, I'm not a big football person, so I know a little bit about it. What is that what's that going for?
Sure. Well, everyone knows. I mean, if you just you happen to catch some football on TV, I mean, you know about the collisions, the impacts. You've probably seen where the whole stadium comes to a standstill while you wait for somebody to get up and keep your fingers crossed and pray that they get up. Well, all of that is a lot of it is resulting in head injury, and head injury that isn't necessarily easily noticeable. Things that over the years now we've become much more educated on the impact of concussions on the brain. You look at sports figures like Muhammad Ali and how he's ended up with Parkinson's because of all the blows to the head. And what that is that the brain inside, hitting the skull from the impact of having a collision with the head. And this is causing a lot of issues with NFL players that we're just beginning to tap the surface of. And as a result, the NFL has agreed to quite quickly actually come up with this settlement because they say, look, we've put the concussion protocols in effect now. When someone is hit in an NFL game, they have to, if they suspect a concussion, they have to sit out. And sometimes they have to sit out games afterwards because they may still have effects of the concussion. And that's something that the NFL has only recently instituted. But we have players going back to the 70s where they were just, they'd get a concussion, they'd be brought up, they'd give them some smelling salts. Hey, can you see how many fingers I've got? Okay, go back in. And that was it. And they did that multiple times. And I'm seeing these guys, and a lot of them, unfortunately, are, sports figures and heroes that I've had over the years of watching football. And I see them in my office now, and many of them have tremendous troubles. We're talking about not just Alzheimer's and Parkinson's, but ALS. There's been a lot of awareness about Lou Gehrig's disease, also called ALS. And these are all incorporated into the NFL class action settlement. So if players, and we talked about the BP settlement and how that works, it's very similarly, this settlement, which has undergone tentative approval, not yet final approval by Judge Brody, but we're expecting next month or within the next few months for her to give final approval to this settlement. So we're already signing up clients. We have many NFL clients, many former players, and we're talking to them and having them looked at, and we have medical experts that are looking to see what type of injuries they have. If you have a certain minimum level of injury, not only do you get free medical care under this settlement, but you will also get monetary awards. It has a grid which progresses all the way up to ALS, which will be a $5 million recovery. So it's something that can really help out a lot of folks. So you hear, we were talking a little bit about wanting to opt out of certain things. This is where you need to make that determination. If somebody is so severely injured that they want to opt out of the settlement, if they feel $5 million will not be enough to compensate them for their lifetime or to compensate the family, then they may want to consider a private lawsuit. But we are operating under the settlement at this point. Just about everybody we've signed up, thank God, falls within the settlement. We don't have somebody that looks like they're definitely going to have to go to a private lawsuit. But we are taking care of them, and we're seeing players and helping them evaluate their situations and file for this.
Now, is the settlement a definite thing, or will they do the same thing that BP tried if it ends up to be many more millions of dollars that they, than was expected?
I wouldn't be surprised. It is a definite thing in that the judge has finally given tentative approval to it. She's had a fairness hearing 2 months ago to review it, so everything seems in order. She doesn't seem to have any major objections. We're just waiting for her final approval. So as far as a settlement goes, yes, it looks like what we see on paper now is what we're going to have. You mentioned the little things that a lot of defendants try to do once they agree to a settlement. And yes, we do suspect that there will be little things, little traps, things all along the way that folks could fall into. Very important to consult with an attorney. We're happy to do that. There's no cost to them. Any money we get is on a contingency fee basis once we apply for the settlement and the money is received in hand. So, and it's a very small amount. It's not the normal third. It's much lower. So it's one of those things where it really can't hurt to consult with an attorney.
All right, now let me ask you something more
Sure.
from a legal standpoint. Isn't it inherent to the nature of the game that you're going to get injured, and do the players already have existing health care to cover that? That's my first question.
Right. Well, in some cases they do. There's some medical coverage, but we're talking some very severe cases. So this is something where they really need, in some instances, to be cared for hand and foot. I mean, in a facility where they're fed or help to the restroom and that sort of thing. And that is something that no insurance is going to cover fully. So this is, in fact, the way I've been describing it to a lot of the players, I'm saying, look, have yourself evaluated under the baseline, which is the minimum to do. You have an assessment by what's called a baseline assessment provider, who is a neurologist and also a neuropsychologist. And the two of them assess the player to see, because if they don't have anything right now, that's great. We at least have a baseline. I'm glad. We don't want anyone to have a health issue. But if somewhere down the line, say 10, 20 years from now, their kids bring them in, something's wrong with grandpa, whatever, then this can kick in. So it does act as an insurance policy for the rest of their lives. The settlement will go for more than 60 years. So at least this will cover them if they get anything down the road.
So would that include NFL players of the future? In other words, do you think that this settlement will change things for when a player goes under contract with the team? Does that still protect the new players, or will it change things as a result?
The settlement doesn't protect the new players. The NFL claims that the new players, in fact, the settlement only takes care of players who are retired. The NFL claims that they've fixed the issue, that they now with their new NFL with their concussion protocols, these will not be issues. That if a player gets a concussion, they're held out, they're examined, the various tests are done, and brain scans and that sort of thing to make sure that they're not going back on the field and taking multiple concussions in the same area.
Okay, now I know you can't give the names, obviously, of players that have come to you, but what are you hearing from players?
It's interesting. You have everything from headaches, were fairly minor, but a lot of memory issues. A lot of times, I hear from players that say, "I went on a trip, and next thing I know, I was driving and I was parked somewhere, and I didn't remember how I got there." So you hear a lot of those types of stories, it's seeming like blank out episodes where they'll sort of, "How did I get here?" They're kind of foggy about that. Many have neurological feelings of things crawling on them. The skin is a neurological issue for a lot of them. And like I said, migraines. Many have severe migraines, and they work on this. And the sad thing is, Lori, this is in addition to what you would normally expect from a retired football player, which is all the aches and pains. And I know some that have replacements of just about every joint with metal, and they have all the pains associated with that. And then to have this. So I'm seeing rage. We have a lot of rage issues where you might see somebody and they seem like they're totally capable and thinking and understanding, but some little thing sets them off and suddenly they find themselves in a rage. So that is a certain concern from a brain injury standpoint. Many different things, and all of that is what a lot of the neuropsychologist is looking at and a lot of what the neurologist is looking at.
Right, and I would think a lot of chronic pain, because when you beat your body up that badly, that's what's going to happen. Right.
But the settlement is only going to assist in the brain injury capacity. So, yes, they've got all that other stuff, and that they're going to have regular private insurance for.
Okay. Now, what happens if their symptoms get worse? Let's say they've already settled, but now their symptoms get worse. What happens?
That's a good point of the settlement. The grid allows you to have a second checkup, a third checkup, as many as you need throughout the rest of your life. So if you do develop something, God forbid Parkinson's, ALS, 10, 20, 30, 40 years down the road, then you would get the compensation for that. And the compensation starts with several $1,000s and moves all the way up to $5 million. So you would get let's say if you had the worst case scenario, you would get $5 million, but then subtracting out what you had received previously if you were in a lesser, healthier, shall we say, position earlier in your life.
Okay, now, what if a player wants to sign up? What do they do?
All they need to do is to see us. Once again, they can call. My number is very easy. It's 712-ERIC, 712-3742. That's 813 here in the Bay Area. And we will meet with them. We discuss what type of injuries they have. We will be able to arrange for them a meeting with one of the baseline assessment providers. As soon as this settlement is finalized, we will have that baseline assessment program start in effect, and we'll be able to do the baseline test. So that will show where they are now. If they have any injuries, that'll be compensated. If they don't, then this is the baseline for what they may be able to get down the road if they get worse. Okay,
now, kind of separate from the NFL, but still applicable in the sense of injuries.
Yeah.
What about these young, kids that play football in school, or what about
Sure.
the college teams? What do you think? Is anything going to happen to help people or warn people that, hey, because, you read every once in a while in the paper some young kid got paralyzed by playing football with or without a helmet.
Yeah.
What are your thoughts on that?
Yeah, well, the one thing is that the main thing is awareness. We are starting, and this settlement is certainly bringing more awareness to the fact that multiple impacts on the head area can cause serious brain issues, serious neurological issues down the road. And then also, yes, there are multiple, if you will, class actions that are being considered. One is against helmet makers, because in many cases, certain helmet makers, they even had names like concussion proof and things like that.
Wow.
Yeah, exactly. And players were told, don't worry, this helmet will protect you and that sort of thing.
That's a lawsuit waiting to happen, right?
Right, and there's many of those under consideration. There's also some under in college organizations being looked at now. But right now, I think the main one, the standard, and what everyone's looking at right now is the NFL settlement and how that will happen and how effective that is going to be. And depending on that, we may see others.
All right, you brought up the helmets. Now, is there a certain standard or spec to which a helmet for the NFL must be? In other words, is there one that's better than the other?
You would think, and over the years, there have been many that have developed with these claims that they were, quote unquote, concussion proof or, better, more protective than others. No, as far as we know, the NFL doesn't have any particular sort of standard. The player protection is something that is very much left to the manufacturer and their research that they say that they've done or that they say that they've done. So a lot is looked at into protecting the player, certainly after the fact and certainly now before, but back then, gosh, we're talking about, we were just after the days of the leather helmets. Remember, they used to put those on.
Yeah.
Remember those from the old Three Stooges movie?
Yes.
They'd be wearing those.
Oh my gosh.
Wearing nothing.
A lot of stuff. All right, well, we're going to take a quick break and we'll be back in just a second.
I've had my shots and kicked in my face, but I've come through. I need to go on. We are the champions, my friend.
Hello, I'm Jim Velasquez. Does getting a lousy 1% on your CDs make you sick to your stomach? Inflation is hovering at 3%, so what's really happening? Allow me, Jim Velasquez, to send you my free report. If you haven't reviewed your CDs in a while, don't get this report. It will break your heart. If you want to fight back and beat the bank, text RETIRE to 72727 for this free report. Let's beat the bank. Text RETIRE to 72727 for your free report.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed. Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
I've made a few. I've had my shots and kicked in my face, but I've come through. I need to go
Welcome back to the Half Empty, Half Full Talk radio show. My guest today is attorney Eric Seidel. We've been talking about class action lawsuits. Mm-hmm. Let's talk in this segment about legitimate class action lawsuits. I'm going to actually kind of let you go through the little list.
Sure.
But talk about some of the ones that are legitimate and how you know that they're legitimate.
Right. Well, one of the ones that our office is looking at, and there are several, but a main one that we've talked about a lot is testosterone, because a lot of people are taking this. A lot of guys are taking this. Obviously, many doctors prescribe this as the manufacturers describe it as sort of a virility, energy, sex drive kind of thing. And you rub this on, and you don't really feel like you were in your 20s anymore. So you rub this on, and wow, you'll feel great. And then you see the folks in the gym that are taking it. I actually know a lot of guys when I go to the Y, they're all cut up and they're talking about how testosterone has helped them do this. But the problem is that in this class action situation, that there's an accusation that they fail to warn of common risks like heart attack, strokes, and we're talking about ischemic strokes, in other words, a clot in the brain, because what this tends to do is it tends to magnify tumor situations. So it can cause like a clot that would cause a heart attack, or it can cause, like I said, a stroke. And we've actually seen a lot of folks like that. I was interviewed on one of the stations, I think it was ABC Action News, came out and did an interview with me, and they asked to see one of our plaintiffs, and I actually had a guy who was very honest about how he took it and how he had heart issues after that. And we had many folks call our office after that had heart attacks. So very serious.
But does the doctor that's giving the medication, aren't they supposed to be clearing that patient of heart issues before they start? Because I know someone that had a heart attack from one of these medications a few years ago and survived, fortunately. But isn't the doctor, or does the doctor not bother to check out their heart before they give them the medication? Because, you watch the commercials on TV that says at the end, real fast, if you had this, or this, it's going to do this, this to you, and it could be fatal. And you go, who would take this?
Right, exactly. Well, in these cases that I'm describing, we're not talking about medical malpractice. These are class actions or proposed class actions that are against the manufacturer themselves. So, as part of that, the accusation would be that the manufacturer didn't provide all the necessary information to the doctors, or that the information was not described as accurately as it should. They may say there's a risk for this or a risk for that, but just didn't emphasize that enough. I can tell you, in many cases, it's much easier for the manufacturers to get away with explaining all those symptoms and then avoiding class action lawsuits, which is why you have, it's almost comical. You see these commercials where they have music and they show a guy and he's having a great time and all that, and then about seemingly that second half of the commercial is all a guy talking fast about all the or girl.
They speed through it so no one can understand it.
Exactly, and they realize that they have to do this now because it's costing them so much if they don't describe a lot of these risks.
All right,
we're talking about risks that weren't described, even in those commercials.
Well, what about the FDA? I mean, does the FDA is supposed to monitor or what they're saying, correct? But does that really work, or not all the time?
If they report the issues to the FDA, that it may be a test where they just hid the issues, and we're not necessarily saying that that's what happened in this one particular case, but in many class actions, the risks were known and they were not described to the FDA, or in many cases, the advertising was done contrary to what they said they were going to be using it for. So there's many different issues in which the FDA does not necessarily know everything that's going on, and in many cases the FDA issues the recall itself. So
right. Now,
that's why you find out.
I know we're talking about class actions. I'm going to give you an example of somebody I know that took a medication and her hair fell out, started falling out. And it wasn't there was nothing on the insert at the time that said anything about that. Now, I have a friend who's a pharmacist who basically said before you take medication, what a consumer should really do is go to the website of the manufacturer of that drug and read through. But I don't think most people are going to do that.
No.
You're lucky if they read the insert, because they're going by what their doctor told them, correct?
Exactly. Or something that is very, very bold on the packaging itself. And that's why in many cases the FDA will say, from now on, this has to be in this size letters on the packaging, saying, could be serious heart injury, check with your doctor if you have a heart issue, that sort of thing.
Now, when a manufacturer, when you have the class action lawsuit, I'm assuming it doesn't involve the doctors, because the doctors were just going by whatever the manufacturer told them. So it's all the manufacturer.
Exactly. It's totally a class action. And in fact, in many cases, the doctors are on our side. You don't want the doctor to be the one that's at fault, obviously, because what you're talking about is the fault on the part of the manufacturer. So the doctor can very often describe exactly what the reps said or provide the literature that they were given. So in many cases, the doctors are actually witnesses for the other side, for the plaintiffs. I should also mention that a lot of these things never go to court. These are settlements, because what you would do is you would then provide all the information that you have to the other side through discovery, and then they would say, well, it looks like we're going to settle this, and that's when you have these settlements. So many of them don't go to the court. But a few more drugs just to mention out there. A lot of them are blood thinners. Xarelto, which is sort of the newer blood thinner that a lot of people are given. We used to have many of these blood thinners that were taken and had to be monitored. In this case, Xarelto, the new benefit, or the benefit that was said, was that it doesn't have to be monitored as much. Unfortunately, we're seeing now that it may cause uncontrolled internal bleeding, and once you have that sort of bleeding, there is no way to take an antidote to it. So many people had serious blood pooling issues from that. So we're looking at that. Plavix, also a blood thinner that's used to prevent stroke or heart attacks. Well, they're saying in many cases the accusation is that they failed to properly warn of the risk of heart attack, stroke. We have gastrointestinal bleeding, cerebral hemorrhage, and death. So that is certainly a class action that many folks are looking at. And then we have ones that don't necessarily involve drugs, but involve medical products, like we talked about replacements, like hip replacements or knee replacements. And this is really interesting. They deal with the metal-on-metal type of hips. And you've probably heard of this because, the way a hip replacement works, or any type of replacement, there's usually a coating on the inside between the ball and socket. A joint is just basically a ball and socket. So you have this, it was sort of a plastic type coating that was in there. And that's what would wear out. So many people would say, if you have a hip operation or replacement, 10 years, just know you're going to have to do it again, because that's what wears out. So the manufacturers came up with this, what they thought was an ingenious idea. We removed that liner, and instead you have what's called metal on metal. So just like, let's say, a Terminator body, like in Terminator, right? You would, if you were to melt it all down, you would just see metal on metal. Well, the problem with that is that with each step, we're finding that metal ions were being ground. The metal was grinding directly against the metal, and metal ions were being released into the bloodstream as a result. So many people had metal toxicity, various types of cobalt poisoning, various types of illnesses as a result. And not only that, but then the pain of all the other metal on metal issues. So these are all metal on metal hip replacements that are coming under class actions. There were the famous DePuy hips that we saw the commercials about. The knee replacements, same thing with the metal on metal. It's one of those things where, it sounded like a great idea, but apparently the testing didn't go far enough, because now, can you imagine after having a whole hip replacement, now to have to go through a procedure to take that hip out again? Oh my goodness, yeah, it's awful.
So what happens in these class actions where they're won? In the hip replacement, for example,
right.
Are they winning enough money that now that money is going to pay for them to go and do another hip replacement for something that's not going to affect, or is there money in addition to them getting that surgery done?
Both. Well, there's the hope, of course, that the money will allow them to get a second hip operation. But unfortunately, Lori, what we're seeing is that so many people have had this operation and they can't have another one because the bone has already been affected so much that once this comes out, you're going to have to put it in, and it just won't be able to be attached. So in many cases, people have to suffer through it. They have to be in a wheelchair perhaps for the rest of their lives. So yes, there is certainly enough money in compensation that is asked for in these cases. And again, just like any other class action that we described where the damages are different, there's very often a decision made as to how much money can be achieved within like a grid pattern. In other words, if they cannot move anymore, here's how much you'll get, and that sort of thing, as opposed to just, maybe we should take it out preemptively.
All right. Now, when there's a class action lawsuit, for example, I know your firm handles that, obviously. Mm-hmm. Do you represent clients or consumers from all over the country? Can you do that, or is there a different one in each state? Because how does that work? Is it federal law?
Yes. What happens is in many cases a class action is consolidated. Many actions. Let's take the NFL for instance. Many folks were suing. Many former NFL players were suing their team. If they played for the Jets, they would sue the Jets. If they played for whatever, and then many people would sue the NFL. And what happens is under the idea of judicial economy, all of these are consolidated down into one district, in which a federal district in which the class action is held, same as any other class action.
All right. Now, in a class action, these consumers, they're not paying any fee to the attorney up front, correct?
Correct, exactly. They shouldn't be paying anything. It's all done on a contingency fee basis. And in fact, in many cases, and I know we'll talk about this later, you can almost see the consumers are getting the short end of the stick, because you have all the money in some illegitimate cases, some others that are just very minor. You just see all the money going to the attorneys and not enough of it going to the consumer. Not in these serious cases that we talked about, but in many of the ones where it'll be like against a beverage or against a certain large advertising company or something like that. But no, you shouldn't have to pay anything up front. Generally, the class action, the named member of the class action, the party that you see on the header, that person generally gets more than the rest for being the named plaintiff in the class action. But other than that, no, you should not have to pay. None of them would have to pay the attorney up front.
What's the average percentage? Is there a range that an attorney firm would charge? From 10% to 40%?
Sure, it depends.
Depends on what it is.
There are different ones. In many cases, the attorney's fees are determined in the class action settlement itself. So in let's say the NFL, the proposed amount is 25%. In the BP situation, it's variable. I mean, our firm only charges 16%. So it's sort of you can go as high as whatever the court determines, and certainly you can go lower. And very often our firm will choose to go lower because we just want to be able to be competitive.
Gotcha. All right, we're going to take a quick break, and we'll be back in just a moment.
Sure.
I've had my shells and kicked in my face, but I've come through. We are the champions, my friend.
Hello, I'm Jim Velasquez. Does getting a lousy 1% on your CDs make you sick to your stomach? Inflation is hovering at 3%, so what's really happening? Allow me, Jim Velasquez, to send you my free report. If you haven't reviewed your CDs in a while, don't get this report. It will break your heart. If you want to fight back and beat the bank, text RETIRE to 72727 for this free report. Let's beat the bank. Text RETIRE to 72727 for your free report.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health. Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
I've made a few. I've had my shells and kicked in my face, but I've come through.
Welcome back to the Half Empty, Half Full Talk radio show. I'm Lori Zook, and I've been speaking with attorney Eric Seidel. We're talking about class action lawsuits. Now, in this last segment, Eric, I want to talk about class actions that are consumer ripoffs because we want to protect our listeners. So why don't you talk a bit about ones that were consumer ripoffs, maybe ones that you think are consumer ripoffs?
Sure. Yeah. Let me give you my opinion on some of these.
Okay.
Well, I remember covering this on Fox 13. Remember the perfume class action? The idea was that, and you still see this a lot, but I remember it was very big over the past 3 or 4 decades. If you wanted to buy perfume, and a lot of guys know this as buying perfumes for your wife or your girlfriend, you'd go into, let's say, a department store, and the price was about the same at Dillard's as it would be at Macy's Macy's as was about the same as at Nordstrom's. They were all about if you name a brand of perfume and it was $100, it was going to be $100 everywhere. You weren't going to go someplace and get it for $88 or, look in bargain shop and all that. Well, they figured that out. The manufacturers were not allowing the retailers to discount their perfumes. It was just one of these things they came up with to try to keep up the high end of the amount that they would charge. Well, consumers, were apparently getting onto this, and several attorneys general sued the perfume manufacturers, and they came up with a settlement. And it was so funny because I remember the settlement was you could pick up free perfume, and what they did was they gave away basically what amounted to samples. They were a little bit larger than samples, but they were of very specific scents. I think they had one for guys, and then they had 2 or 3 for ladies, and they were the aftershave in like a smaller bottle, and the lines were all down the mall. I remember when we covered this, you could go to like University Mall or any of them and just see people lined up outside of whatever store was doing it at that particular day. It was so funny, and you'd line up, and they had a certain amount. When they were out, they were out. So I saw people, oh, look, I got the soap, and you got this. It was really funny.
That's crazy.
I know, but imagine what the lawyers got. I really don't remember exactly the amount, but obviously the lawyers, or if it was the attorneys general, then the attorney general offices got a certain amount, but the consumers really got the short end, because if you're willing to wait on all that long line for a free little sample, then God bless.
That's nuts.
It was so funny. We've got one that just settled the Red Bull class action. This one settled for around $13 million. It's been on a lot of the papers, a lot of the internet. The manufacturer, they have that slogan, Red Bull gives you wings, and that it supposedly revitalizes or vitalizes your mind and body due to this, what they say is a unique mixture of ingredients that supposedly improve your mental and physiological performance. Well, it was alleged that Red Bull is no more effective than a cup of coffee, because they say after scientific studies were shown that the main effective ingredient in this was the caffeine, and it was about the same as you would get in a cup of coffee, or a caffeine pill. And the funny thing was okay, so the settlement, what do the consumers get out of it? It was the potential award a coupon for Red Bull products, so you can enjoy some more.
That's crazy. Right. And you know how many people I saw over the last few years drinking the Red Bull, saying that?
Exactly.
Because that's what they're being fed through the marketing.
Exactly. And it's effective because, it's effective like caffeine is effective. Coffee. Yeah, exactly. So, I guess, and people like the flavor. I know plenty of folks like, oh, I love that. I'm hooked on this stuff, and they love it. They love it. But interestingly enough, that was one class action settlement.
Well, wait a minute. If people get free Red Bull or free perfume, the lawyers are getting all the rest of the money.
Yeah, exactly. Or in many cases, the attorney general offices. And in that case, it does go back into the state fund. We had many.
It's a revenue booster for the state.
It is, and
that's nuts. Okay,
that's what many of them are here in Florida. But here's the pro part of that, Con, is that it would then be a penalty against the business to stop the deceptive, or what is considered deceptive, marketing. Because look at how much it's costing you, whether it goes to the attorney general or whether you have to give away some free products. It's not a good thing. In other words, stop, cease and desist. And in fact, along those lines, we had this one against vitamin water. There is a deceptive marketing class action settlement where the plaintiffs claim that the guys that make vitamin water overstated the nutritional content with marketing labels that say things like, this combination of zinc and fortifying vitamins can keep you healthy as a horse. Wow, that's great. And then they've got this little catchy one where it's vitamins, then a plus water equals all you need, right? So they basically further allege that the companies mislead consumers into believing they were buying a healthy product when in fact vitamin water allegedly contained almost as much sugar as brand name Coke. So the potential award in this case, stop the deceptive marketing. So
there's the punishment factor,
right,
in other words.
There's the punitive, the punishment factor in it. Now, in some cases, and this is something that I know you feel very strongly about, there's the punishment factor, and a lot of that can go to consumers. The robocall case, remember the Chase robocall bank, where they were calling people and they're automatically, the estimated consumer payment is only between $20 and $40, and this is just an estimate, but the amount of compensation that the class members will actually receive depends on the total number of timely and validated claims submitted. And validation is often the problem here, because what you need to have done is, just like a local case we've had against a local bank, you need to keep track of these things and be able to show the proof of the calls. So, you want to keep a chart of this. You can't just say, well, yeah, they called me probably 5 times over the past 5 days. You need to actually give the time, write it down, the phone number, the representative if someone talks to you, get a name, get a number, write it all down, and keep a log, or even say, just send me information, tell me, send me what you think I owe.
I'm going to jump in here and tell you an easy solution, because as a credit consultant, I get this is regarding the telemarketing laws, but you also have the Fair Debt Collection Practices Act and Florida Consumer Collection Practices Act for the debt violation. And what I tell clients to do is, if they're getting robocalls, use their cell phone or use someone else's cell phone and take a photo of that call.
Perfect.
So it shows the date, it shows the time, and it shows the phone number. And when they continue to do that over and over, you have a picture. A picture log, so to speak.
Perfect.
Now, sometimes they're not robocalls, though, and you'll actually get the debt collector on the other end. And you can say cease and desist, and really you should send a letter to protect yourself, certify, return receipt.
Absolutely.
But a lot of times, they still continue to call over and over.
Well, that'll take care of the validation, like you said. Taking a picture. And you don't need to do it for absolutely every one of them. Keep a grid and keep a few pictures. That's going to be more than enough to validate your claim and certainly get the highest award under that class action.
Right. And one of the things I mentioned with the Nelson and Joyce Coniglio case, that's where they won the $1 million lawsuit against Bank of America.
Right.
Now, of course, the bank is appealing the decision.
Right.
You know where we can go on that. But yeah, you do have to keep the validation. What evidence does an attorney typically need from a client in a class action? Obviously, not when we just talked about it, but what evidence? If it's with doctors, they're going to seek medical records.
Right.
Correct. So, in some of these other cases that you talked about, how do you prove it?
Right. Well, you would want to subpoena documents. You would want to obtain the type of evidence that you need in writing, hopefully, if there were tests that were done, if it's a particular pharmaceutical and that sort of thing. You want to subpoena and obtain those documents. However, like I said, most of this will not go to court. So once you have enough, and I guess the question is, what is the tipping point? Once you have enough, then a settlement is generally on the table. So we're talking about, okay, you don't want to get for instance, in the NFL does, the speculation is that it does not want to have to give up all of its medical records and try to show what they knew about each particular player. And on the other hand, each particular player doesn't want to have to try to go into their attorney and prove every time they had a concussion. So this way we reach a general, shall we say, inequality in which we agree that we may not have totally all the evidence here, and you may not have some of this documentation may hurt you over here. But let's reach an agreement. Let's reach a settlement before we give it over to a judge to then say, yeah, that's enough or this is enough. So in many cases, it's pretty much up to the both parties to decide how much they have on each other.
I gotcha. Okay, so if they settle out of court, then it shows up in the court records, and I'm assuming that they sign some type of a non-disclosure where they can't state how much they got from that particular company?
In some cases, it depends on what the settlement agrees to. When we have somebody and they're getting a check in the BP situation, they do have to sign a waiver against suing BP again, and this is all they're going to get in that amount. And if they agree and this is a satisfactory amount, then you would sign off on that. And if it requires you to remain silent on it, then that might. In most cases, I haven't seen that in the BP settlements.
Oh, so in the BP, you actually could come public and say, I got X amount of dollars, and they can't do anything.
But I will say that it's also a private settlement. Many people are concerned, that somehow there's going to be a lot of publicity over how much a certain company got. And if you choose to keep that quiet, then under the judge's order, that will remain quiet.
Okay, gotcha. All right, in 1 minute, give me an example of somebody thinks they have a potential case for a class action. What do they do?
Well, if they think they have a potential case, the best thing, obviously, is to seek an attorney who does class actions, and we can certainly help with that. We would review their case, see if it is something that fits the guidelines, or if perhaps there already is a class action out there. That's why you see many of these commercials on TV where they advertise. That usually means there's a class action out there, and local attorneys are trying to, if you will, chum the waters, get whoever they can so that they can refer them out to those folks. We don't do that. Obviously, we do all of our work in-house. So anyone can feel free to call. It's 712-ERIC, area code 813-712-ERIC. That's 3742.
Okay, last thing, to prevent people from being scammed. Sometimes I see non-attorney firms. They almost make it look like for example, in foreclosure, that they're representing you, but they're really not attorneys. Or they might have an attorney on staff, but the attorney. So how do you find out if a company is legitimate or if a law firm is legitimate? Sure.
Well, find out. Ask the name of the attorney, and you can look it up on the Florida Bar website to see if they are an attorney. In most cases, people will not take a chance on running a risk of claiming that they're a lawyer when they're not. But you should always check. In the BP situation, we had plenty of folks who were just the salesperson of the day. They might be selling Amway today.
Right.
Next thing they were going around is getting a bunch of BP cases. But then what they did was then they had to go around try to figure out how they were going to file these things, and if they needed a lawyer's help, then they needed to go to the lawyer. So you're probably, in the best case, best off going to an attorney the first time around.
Great. I want to thank you very much for joining me. Give out your contact information one more time.
Sure. It's 813-712-ERIC. That's 712-3742. Certainly easy to remember that. And just give me a call, and we'll talk about whatever needs to be done.
Website?
Oh, it's that's pretty easy, too. You can go to ericcanhelp.com, or you can go to our regular firm website, which is mcintyrefirm.com.
Great. Well, join us every week for a new half-empty, half-full consumer advocacy talk radio show. Learn something new every week and get smarter faster. Be safe.